Well, thanks everybody for joining us. We've got a big crowd today. I just want to mention a couple of things first. This Teams live event uses Microsoft automatic speech recognition to generate live captions. Just select the three dots on your toolbar and turn on live captions, and the translation feature is enabled to help those who prefer languages other than English. My name is Rob Hulls, and I'll be facilitating today's discussion. I want to start by acknowledging the traditional custodians of the land on which we meet. RMIT acknowledges the people of the Woiwurrung and Boonwurrung language groups of the Eastern Kulin Nation, on whose unceded lands we conduct business of the university. RMIT University respectfully acknowledges their ancestors and elders past, present and emerging. And the university also acknowledges the traditional custodians and their ancestors of the lands and waters across Australia where we conduct our business. Well, the age of criminal responsibility is, as we know, that age at which a person can be arrested, charged and found guilty of a criminal offence. In all Australian jurisdictions, this age is 10. Yep, 10. This is one of the lowest ages of criminal responsibility in the world. In fact, under international human rights law, the minimum accepted age for criminal responsibility is 14. Can you cast your mind back to when you were 10 years old? Wow, I've got to say it was a long time, very long time for me, but I think I was in grade 5. I reckon I had moved on from Enid Blyton books like the Magic Faraway Tree and the Secret 7. Just move on from them, not by much. I did my shoes up, I remember, by putting a bow on each side of the shoelace. It took ages. I remember being taken to the 1967 grand final when I was 10 and crying for a week when my beloved Cats got beaten by Richmond. Let's hope history doesn't repeat itself on Saturday night. In other words, I was just a little kid who was still learning the basics. I was very lucky because I came from a middle class family in Melbourne. I had no history of trauma or dispossession, or indeed disadvantage in my upbringing or background. Sure, as a kid, I did lots of very silly things. I won't mention them all now, but as most kids do, I did a lot of silly things. But in overstepping the line, I got the support and guidance that I needed because I was a child. Many children, however, don't have these structural and systemic advantages that I had. Imagine a 10, 11, 12 or 13-year-old child who has grown up in a context of family violence, alcohol abuse or intergenerational unemployment, or where that child's grandparents or great-grandparents were snatched away from their families. Imagine young kids with intellectual disabilities, with poor mental health, with impaired cognitive functioning, with fragmented school involvement. These young children also need support and guidance when they make mistakes, arguably much more support than a child without protective factors in their lives. Instead, our low age of criminal responsibility means that many of these kids, around 8,000 a year in fact, are proceeded against by police, with over 600 imprisoned in detention facilities. Many of those detained are on remand, not having yet been even found guilty of an offence. Is this really what 21st century justice system should look like? What are the real impacts of having such a low age of criminal responsibility? To discuss these very important issues, we have a fabulous panel. Let me introduce the panel members to you. First of all, we have Nerita Waite. Nerita is CEO of the Victorian Aboriginal Legal Service. Nerita, in 2014, commenced working with the Victorian Aboriginal Legal Service, where she started as a civil lawyer, then moved to family and youth team. In late 2016, Nerita moved into a dual role, undertaking both legal casework and policy work, and was able to establish Ballitnalu, a specialist legal service for Aboriginal and Torres Strait Islander children. Nerita, thanks for joining us. We also have Leanna Buchanan. Leanna is the Principal Commissioner for Children and Young People and a part-time Commissioner of the Victorian Law Reform Commission. Leanna has worked in a range of roles focused on social justice reform and system oversight. Before starting as a commissioner in 2016, she led the peak body for Victorian CLCs, the Federation of Community Legal Centres, and was responsible for monitoring Victoria's correction system as Director of the Office of Correctional Services Review. Leanna, thanks for joining us. And we also have Anushka Geronimus. Anushka recently joined West Justice as their Youth Law Program Director. She was Youth Crime Program Manager at Victoria Legal Aid for nearly 7 years before this. She's an accredited specialist in both children's law and criminal law, and sits on the Law Institute's Children's Law Specialist Advisory Committee. In 2012, in fact, she received the National Children's Lawyer of the Year Award for work she did on the Tyler Cassidy inquest along with VLA. Anushka, thank you very much for joining us as well. Well, can I start with you, Leanna? We have a very big audience joining us. With no doubt a breadth of different experiences and exposure to this very important issue. Many people in the community may be shocked to learn that kids as young as 10, not only bear the burden of criminal responsibility, but can actually be imprisoned as a result. Others may take the view that, oh yeah, well, bad luck, you do the crime, you do the time. What does it mean in reality for a kid 10, 11, 12, 13 to be criminalised, and what's it like for a child to be in a custodial environment?
Thanks, Rob. Well, you just told us a bit about your memories of being 10. I reckon most of us would have a 10, 11, 12-year-old in our lives. Imagine that child's stature, that child's maturity, that child's capacity to understand what's going on. Imagine that child being arrested by police, being held in a police cell, potentially overnight, maybe coming before a bail justice, remanded into custody, being transported into Parkville Youth Justice Centre. They come in, they're searched, they have to hand over their clothes and their property, they're asked a whole raft of questions and ultimately put into a room which we have to say is a cell on their own. Now, a lot of people, if they haven't been to Parkville or our other youth justice centre, might imagine that youth justice facilities are small, home-like environments that really kind of reflect this notion that we are out to rehabilitate children. The reality, certainly in Victoria, is very, very different from that. As you mentioned, I've done jobs that have taken me into every adult prison in this state, and I'm on record already saying that Parkville, where young children are taken, boys and girls, is more physically austere, more harsh than any maximum security adult prison. For people who haven't been there, when you go in, it's become over the years, as more and more security is added, a bit of a rabbit warren. There's very high wire fences all topped with razor wire. Children can't be moved around to go to a health appointment or to school or to programs without having staff escort them. It really is, my best way to describe it is think of any US kind of prison show you've ever watched and imagine a grade 6 or maybe a grade 7 in that environment. Now, again, I won't go into detail on this, but we also know that in Victoria, we've had a whole raft of problems in youth justice in recent years. And so you think about those problems, you think about those impacting younger children as well. So we certainly in our work, we've seen young children really suffer through these staff shortage lockdowns that we've had. We've seen one young boy self-harming because he just wasn't coping. We've seen young children self-isolating because they're scared of other kids in the unit. We've seen young children not able to get their visits because their mum doesn't have the right ID or she lives too far away. A whole raft of issues that affect our youth justice system, and that are, there's work to try and address them. But the impact on a young child, we can only imagine how devastating that will be. So, unsurprisingly, this does not work to stop children from reoffending. The evidence is really clear. It has the opposite effect. The younger a child comes into the system, the more likely they'll come back again and again and again. So really, that's what we know. That's what I see when I go into youth justice. That's what our staff and visitors see. There has to be a better way.
Well, it's pretty stark, Leanna, what you've just told us. And Anushka, to you, other kids may not end up in custody, but we know they can still suffer some of the I guess, negative criminogenic effects of justice system involvement with the system. From your work as a lawyer practicing in this space, what's the experience of first contact with the justice system like for a kid? What kind of trajectory, I guess, does this spark?
Thanks, Rob. Rob, from my experience, the first contact with the system is pivotal. It actually has, and the experience it's pivotal because it determines whether you're likely to stay out or return. Liana's already given us a sense of kind of what the system looks like. And when we talk about the system, it encompasses that very first contact with police, that very first arrest, that very first time that you were in the back of a divvy van, right, the very first time you speak with a lawyer, the very first time you come to court, and the very first time you speak to a lawyer. In terms of my first contact with a child under 14, the first thing that you kind of think is they're waist high. They are children. They're tired. They look really grumpy. They're hungry. They're crying. They're not wearing warm clothes and it's the middle of winter. They're the things that they're the very first experiences or impressions that you get. In terms of, and they're flanked and they're little and they're flanked by workers. That's one of the kind of things that kind of has left an impression over the time that I've been practicing. In terms of the trajectory, if you're on bail, from experience, you usually come back. And usually you come back because you haven't been able to follow the conditions, no matter how hard you try. You might have been out past curfew. You've got into trouble again. And in terms of getting into trouble again, what does that look like? You may have resisted arrest. You have committed criminal damage in the unit. And Rob, once you come back, it is so impossible. It becomes increasingly difficult to stay out. One of the kind of phenomenons that you see is that kids become increasingly desensitized. You've got this phenomenon where kids instruct you that they want to stay in custody because their mates are in there. They feel safer in custody. They get a feed in custody. It's actually easier for them to stay in custody than follow their bail conditions. Now, as their advocate, kind of your instinct and your job is to try and get them out. But these are the instructions that they're giving you, and they're exercising their rights, which is what they're entitled to do. But I think the choices that they have are unenviable.
Wow. Nerita, we know that the current age of criminal responsibility disproportionately impacts on Aboriginal kids and Aboriginal children and young people. What are the impacts of the current laws on Aboriginal children, family and communities from your experience?
Thank you, Rob. First, I just want to acknowledge the traditional custodians of the Wurundjeri country, where I'm lucky to live on for the last 33 years, and pay my respects to their elders, both past, present and future, for they hold the memories, the traditions, the culture and the hope of our people. As many in our community, were deeply disappointed in the lack of leadership shown by the refusal in July of CAG to take the necessary steps to make real systemic change and raise the age, because in our view it doesn't reflect what Australians want, but it doesn't reflect the call of Aboriginal communities and Aboriginal children for decades, Rob. And I'm not sure if you're familiar with the Koori Youth Council's Hear Me report, but that spoke to the experiences of our young ones in youth justice. And it's sad that a lot of our experiences with them revolve around them being criminalised, and a lot of that's due, like Anushka was talking to, is about disadvantage, and our communities are the most disadvantaged across not only the state but the nation. And you see that with our kids who oftentimes don't have a roof over their head, who are in and out of childcare, child protection every other day, who just want to be connected to culture and kin, don't know where the next feed is coming from, and they know that if they are in youth justice and they can be with other mob, But if they continue down that path, they're often robbed, sadly, making plans about what adult prison they'll go to based on where they know their uncles are. And this is sad, and we're also now seeing it happen to our young Aboriginal girls. And it's just frightening. And, you know, the overrepresentation is horrible, it's shameful, and, you know, in the same week the government decided not to raise the age, you see the Closing the Gap agreement was released, with government making a public commitment to reducing the number of Aboriginal kids in custody. And it's incredibly difficult to reconcile that Close the Gap agreement with the decision by CAG, which could have reduced the over-incarceration of our kids by at least 17% nationally, which is huge. And the statistics are horrifying. 31% of sentenced Aboriginal children in 12 and 14. So when I was 12, I was taking really embarrassing grade 6 photos and graduating from grade 6 with great fanfare. But my colleagues at the same age were unfortunately in prison and still continue to be. Many of the children who are imprisoned come from those disadvantaged backgrounds. So when you put them in prison, you just cycle them through. They don't know any different. They don't have a chance to discover joy. They don't have a chance to discover fairness or equality. They don't have a chance at a fair education, or to one day, like yourself, become Attorney General of this state. It's just horrendous. And I know that I'm going on, so I will now shut up and let you ask the next question.
No. Thanks, Nerita. Appreciate it. I guess touching on what you've said to you, Leanna, there is considerable research, as we know, telling us that kids who come into contact with the criminal justice system have often experienced trauma and disadvantage, as Nerita has spoken about. That includes a significant number of children who have been in the out-of-home care system and ended up being funneled into youth justice. What's your commission found in relation to the needs of kids who end up coming into contact with the justice system?
Thanks, Rob. So you're absolutely right that what the literature says, and in fact in Victoria, since the Sentencing Advisory Council did their work on crossover kids, we don't need to guess or speculate. There's incredibly hard data now that shows exactly as you describe, lots of children with a child protection background or a care background make their way into the youth justice system. But for today's purposes, that is even more the case for children who are 10 to 13 when they're first sentenced by the Children's Court. So what we have is particularly a system in Victoria that is for young children, especially criminalising trauma. The data, I won't go into all of the data, but for example, of all of those children across 2 years who were sentenced by the Children's Court Criminal Division, and were kind of 10 to 13, a quarter of those 10 to 13-year-olds were in residential care. Now, at any given time in Victoria, we've got about 400 to 450 kids in resi. So that is a massively disproportionate amount. And following on from Nerita's comments, again, we know Aboriginal children are massively overrepresented in the care system. A quarter of our kids in care are Aboriginal. So it all comes up to, pulls together to be a pretty horrifying story. Now, we see this story every week. At the Commission, we monitor all serious incidents in the out-of-home care system, including residential care. And I was looking through some of the reports, some of the children's cases before today, and I've got to say, these children's stories and the way our system responds to them would break your heart. It certainly makes you incredibly angry on their behalf. These are children who've experienced physical abuse, sexual abuse, neglect, often from very early in their lives and often for some years before they've been removed. Once they're removed, often for those children, particularly who end up in resi, they're cycled through carer after carer. Their trauma, for many, not all but many, manifests with challenging behaviours, acting out. It might start out low level, but it escalates. By the time they're heading towards the end of primary school, these children often are being excluded from school or they're disengaging. We're really starting to see their risk-taking escalate and so on. Now, these children They don't receive early therapeutic support for what they've been through when they're removed from their parent. Rather, the system waits, I've got to say, until their behaviours start to become really problematic for everybody else. And even then, it's often too late. These are children, as your introductory remarks mentioned, who by the time they're offending, that many of them have significant mental health issues. A significant number have intellectual disability, and the raft of issues, including substance abuse and so on, that they're affected by is really quite overwhelming. Then you think about putting them in residential care, in placements with a whole lot of other children, usually 3 other children or young people who've had similar experiences, similar backgrounds, but who might be a bit further along the path of offending or getting into strife. So then there's the impact of peer pressure. And you can see how that process of living in residential care brings them into contact with the criminal justice system, whether the resi workers are calling the police because they're acting out in resi, or when they go missing and they're getting into trouble and conflict there. These children are children who need safety, they need stability, they need the capacity to develop trusting relationships with adults who care for them, they need support to recover from all the things they've been through. Instead, in too many cases, we put them on a community justice order. For some, we put them into custody, and when they come out, again, what we see at the Commission, they cycle through resi, secure welfare, sometimes hospital, and then back into youth justice. Again, we've got to be able to do better than this as a state.
We sure do. Well, Nerita, to you, we know that there are some specific factors that seem to push Aboriginal kids into contact with the justice system. We know, stats show us that Aboriginal and Torres Strait Islander young people are less likely to be cautioned, often receive harsher sentences for minor offences, and are more likely to be processed through the courts than non-Aboriginal young people. Can you tell us some of the factors that lead to this grossly unacceptable level of overrepresentation of Aboriginal children in the criminal justice system?
Certainly. There are a myriad of factors, but I'll concentrate on just 3. Systemic racism, culturally inappropriate legal systems, and overrepresentation in the child protection system. The Black Lives Matter movement has brought national attention to the long-standing injustice that is systemic racism, with the voices of Aboriginal Strait Islander people being amplified by the solidarity of non-Aboriginal Australians. There is a growing understanding that we need to acknowledge the violent colonial history of this country and how this legacy has created structures and institutions characterised by racism that affect my communities. Systemic racism impacts on Aboriginal children in many aspects of their lives, and their experience of the criminal justice system can include police racially profiling them, leading to more stops, searches, arrests, and police choosing not to proceed by way of caution. Cultural awareness and unconscious bias training is not going to address the issue, although that's a frequently proposed solution. That isn't to say that such training isn't crucial, but this issue is deep-rooted, complex, and is ultimately not about individuals within a system that otherwise operates well. And if I reflect on some cases that have come up recently with inappropriate searches of our children, inappropriate arrests, and over-policing, it is because particularly in regional centres, that they know these families and they have a viewpoint that they're there to cause trouble just by virtue of their last name, and that they'll end up in the justice system, so they create the situations for that to occur. Both historic and contemporary relationships between police and Aboriginal communities have been fraught, and a commitment to addressing systemic racism and ending impunity is crucial for moving forward, not just for a safe and equal future for everyone, but in which Aboriginal children can have the same sort of future as their non-Aboriginal counterparts. Independent police oversight is also a problem, but if we just turn to the culturally inappropriate systems that don't account for the legacy of colonialism, one of those is the example of sentencing. Sentencing doesn't often consider cultural inequity of community circumstances of Aboriginal children. It doesn't address systemic issues listed to Aboriginality, including intergenerational trauma, impacts of child removal and land dispossession, and Aboriginal specific sentence options are rarely identified. Liana helpfully pointed to the Sentencing Advisory Council's Crossover Kids report, which found that our sentenced and diverted children who had experienced out-of-home care were 11.5 times more likely than the general population to be Aboriginal Strait Islander children. The overlap between child protection involvement in the justice system is acknowledged widely, including in AJ4, which notes that there is a growing number of Aboriginal kids who experience increased exposure to risk factors for offending, notably family violence, parental alcohol and substance abuse, and involvement in out-of-home care, resulting in greater likelihood of early contact with the criminal justice system. And if we just reflect on our current pandemic environment, this has certainly been more acute, with VAL seeing a 740% increase of inquiries for assistance in relation to these sorts of matters, just because as people are out of work, as people are restricted, not being able to be connected to kin, culture and land, we're seeing higher rates of alcohol and substance abuse, which is then leading to family violence and, of course, removal of children, which will then just end up cycling through the YJ system, as we've also helpfully outlined today.
Well, thanks for that explanation. It's a good answer, but it's not a good answer. And when I say not a good answer, some of the reasons you gave are really quite an appalling indictment on our justice system. But Anushka, to you, in Australia, we have the presumption of Dolly Incapax, which is a rebuttable presumption that kids under 14 are incapable of crime because essentially their brains aren't sufficiently developed to understand the difference between right and wrong. Surely that's a safeguard, isn't it? If we have this safeguard, why do we need to raise the age of criminal responsibility?
That's a really great question, Rob. The simple answer is that Dolly Incapax does not safeguard children in practice under 14. The fact is, to actually determine whether a child under 14 is actually Dolly Incapax at the time of the offence usually requires a number of court events, including sometimes a hearing. So what this means in practice is that the onus falls on the young person to get the safeguard to actually safeguard them. And so in practice, what happens is, so the prosecution has discretion to withdraw charges if they're satisfied that they can't prove beyond reasonable doubt that the child was Dolly Incapax, or that the child actually did have the capacity, the criminal capacity. However, what you see in practice is that this discretion is practiced inconsistently across the state by courts, particularly in regional rural areas. And so what this means also is that depending on where you are accessing justice, you're going to be your ability to get this safeguard is impacted upon. And the most paradoxical thing is, whilst you're trying to get this safeguard to safeguard you, you've got all of these experience, you're being exposed to the very system you're supposed to be safeguarded from. So, for example, you're being, if you are on bail, you might actually be on, you've been you're breaching your bail conditions, you're going back, you're being back before the court in a remand situation, you're being arrested, you're being handcuffed, you're being strip searched, you're being subjected to forensic examinations, you're being interrogated again. And what this means is, by the time you even get a determination, you may end up being found to not have the criminal capacity, but the damage is done by that point in terms of your exposure to the criminal justice system and your ability to stay out of it.
Well, you've just mentioned bail. Can we just touch on that? Because the Sentencing Advisory Council recently published a report which found that on an average day in Victoria, 90 children are held on remand. That means that they're in custody but haven't actually been found guilty of any offence or been sentenced. The council also found that only 1/3 of those kids on remand actually end up receiving a custodial sentence. What impacts are our bail laws having on young kids?
Honestly, quite disastrous impacts. Bail plays a central role in the treatment of children and directly affecting their pathway through the justice system and outcomes. We saw that in 2018, bail reforms being introduced here in Victoria, and there has been a significant increase in the number of children admitted to remand. And this is confirmed by the Sentencing Advisory Council report. The what you have seen in practice is that children are being propelled into the higher bail categories, so compelling reasons or exceptional circumstances, even when they don't pose a really significant threat of further offending, and most perversely, not looking at a custodial sentence. And so I feel for the police. They've got a very difficult job, and they are a really key stakeholder in talking about the solution once we get to that point. They often feel that they're bound to remand kids because of the bail laws, despite having the discretion in many cases to bail them at the station level. Bail justices don't feel confident to release them when they're at the bail justice hearing, and then they're brought to court. And so your experience is that, for example, children in regional areas will be held in cells for longer. You've got children being held in cells that were previously considered unfit for children. You've got children who commit further offences while being on bail, and then they're remanded again, and they're awaiting, for example, I talked about Dolly Incapax. They might be unfit. They don't even have the, they're unfit to plead. And so you've got all of these factors kind of contributing again to the net effect that bail is not actually keeping the community safer, and nor is it having any sort of kind of rehabilitative effect on children when you're talking about kids under 14 in particular and the youth justice system.
Well, to you, Nerita, just on that bail issue, are the impacts that Anushka's spoken about, are they the same impacts on other groups in the community who are over-policed and over-represented in our prisons, from your experience, Nerita?
First, can I just say, from an Aboriginal community perspective, it is illogical that we hold children and adults under the same bail laws, yet those children don't have the same rights, freedoms or responsibilities as an adult, so as a person who is 18 years of age or older. That's something that we constantly discuss as Aboriginal community in our Rajaks and Aboriginal Justice Forum, and it's quite frustrating. And I'm sure that you're aware that in that sentencing advisory report that you mentioned, children who didn't receive a custodial sentence spent 10,750 days on remand at a cost of $15 million. Could you imagine if we had $15 million to put in prevention and diversion activities, therapeutic supports? It is disappointing that year after year I see further investments in prisons and at the tougher end of the system, and yet very little investment in those therapeutic supports and diversion programs that would mean the world to changing the course for a child's life and also that family's life as well. And when we talk about Aboriginal families, that's even more important because we have higher rates of justice involvement. These children come from families where prison is the norm, not the exception. And by not giving them the chance to see that there is an alternative pathway, you criminalise them and you punish them just by virtue of being who they are and who their family is. And you know, in my work across Victoria, some of the key challenges that we see in the bail system are that children and young people alleged to have committed low-level offences are refused bail as they're unable to show cause, like Anushka talked about. Police impose onerous and culturally inappropriate bail conditions on our kids. Youth justice workers are inflexible and culturally inappropriate in bail supervision. And those issues might seem small, but for an Aboriginal kid, those issues are crucial. This is about life and death for them. You know, for many years, Aboriginal organisations such as BOWS have repeatedly made recommendations to the government on measures that will reduce the numbers of Aboriginal people in custody, which include repealing punitive bail laws. The new Youth Justice Act should include a requirement, similar to that in Section 3A of the new Bail Act, to consider Aboriginal as a factor for bail. It doesn't, from what I understand of the latest draft. Like we talked about, we need residential bail support and therapeutic programs for Aboriginal young people. We need to amend the Bail Act so that it's fair and equitable, and not only just for children, which I know is our focus here, but also for, you know, your average Joe down the street. Because if mum and dad are in prison, then these kids have no ability to be within a family unit, to be connected to kin and culture, and that is also a robbery of these children's lives. So thank you, Rob. No,
well, thanks for that answer. Could I go to you, Leanna, in relation to COVID-19, and because of COVID, of course, there's been calls to reduce the number of children in youth prisons. And one of the concerns is that, of course, in addition to the increased risk of contracting the virus in a closed, crowded custodial environment, the steps being taken to reduce the likelihood of an outbreak can also be harmful, and that includes the increased use of lockdowns, reduced oversight in relation to what's happening in our youth prisons. What do we know about the impact of COVID on youth custodial environments and the type of monitoring which is occurring?
Yeah, thanks, Rob. It's certainly been, I suspect, a tricky time for those managing youth justice, and it's been an interesting and tricky time for those of us, as we do at the Commission, who are responsible for monitoring youth justice. On the monitoring, as you'd imagine, we've kept a very, very close eye, very, very frequent briefings and data analysis and analysis of records and so on, to understand what changes are being made inside youth justice and what that means for the children and young people in there. We usually have staff and community visitors going in all the time, frankly, to youth justice, and of course that's been limited. Not all the time. We were able to go in during the kind of pause between restrictions around the middle of the year, but other than that, for our engagement with children in there, we've had to move to virtual monitoring, which I've got to say has been pretty effective. It's not a replacement for going in and looking at the environment and talking directly with young people, but we've had pretty good take up in terms of children and young people who want to talk to us as staff or to our visitors. I mean, your question really nailed it. There's such a tension between trying to make sure that there's no outbreak in a custodial setting and trying to not take such harsh measures or measures with such terrible effects that it really exacerbates what are already pretty tough conditions. So, I mean, I've certainly taken the view youth justice has had to take some measures. I mean, the reality of what would happen for children and young people if there was an outbreak is pretty horrendous. And in fact, we saw a little bit of that. There was some Parkville College staff at Malmesbury, this has been in the press, tested positive. What that meant for children and young people in Malmesbury is that they were in lockdown. They had to be in isolation for periods of time. Not all units, but most, particularly those that had close contact. And similarly, a whole lot of staff were not available because they too had to go home and isolate. So you imagine that and the impact that could have on all children in a centre, potentially being isolated for weeks and weeks and weeks with not enough staff to support them. That's pretty dire. So youth justice has had to take some measures which don't sit comfortably with me, and I suspect with them, but on balance, they've thought them necessary, and in most cases I've agreed. So all children have to be isolated for 14 days when they first are admitted. I'm hoping that can reduce as we move out of restrictions, but that's pretty significant. If you imagine that young child that I was describing at the beginning entering youth justice and being in isolation for effectively 2 whole weeks. Obviously, kids who test positive have to be in effective solitary for a significant period of time, but also school wasn't on site. Parkville College wasn't on site for a number of weeks. They've just gone back in the last few weeks. Visits, face-to-face visits, kids haven't had those for the better part of 7 months. So there've been a whole raft of impacts on children and young people. Youth justice has worked, I've got to say, pretty hard. So they've put a lot of effort into trying to make sure that there's activities, there's devices, there's music, there's laptops for children, young people who have to be in isolation, that they've upped the number of staff who are there to engage with them, putting in wellbeing checks, etc. They also, I have to say, have put a lot of effort into trying to make sure children are well supported, well placed to get bail and to get parole. My view is that level of effort should be in place all the time, and I'll be pushing to make sure that's the case. So look, I think it's been a really tricky time. I certainly know I'm pushing that we kind of move out of some of those restrictions as soon as it's safe to do so. There's one issue. I mean, we've just had a big conversation about bail, and certainly for the 10 to 13-year-olds, most children who are in of that age who are in custody are there on bail. A tiny, tiny proportion ever receive a sentence into custody. So for those children and others, if we'd had some even temporary bail reforms during that time, it might have alleviated some of the crowding and some of that pressure. My only hope is if something like this happens again. We're all hoping it doesn't, but the government might be prepared to give that some thought.
Thanks for that. But I guess even people in the audience today and other people who talk about the age of criminal responsibility say, well, hang on, what do we do with these kids instead? You know, you raise the age. Don't we need a whole new system to replace a youth justice response for kids under 14? What's your view on that?
There's different views. My view is we don't necessarily need a whole new system. What children need who engage in offending behaviour, they need someone to understand what are the causes of that behaviour, what's driving it, and they need a whole wraparound system of supports and interventions to help them and sometimes their family address those causes. They might need that to be supported by a case manager, you know, that's entirely possible. But actually, between disability services where they're relevant, between mental health services, between other therapeutic services and supports, we should have in place in this pretty well-resourced, sophisticated state the supports, the services that are needed. So I don't necessarily think we need a whole new system, but we might need our existing systems to work a whole lot better, particularly for the kind of children who end up in youth justice and particularly at that early age. Of course, some jurisdictions do have a different approach. If you look at Scotland, for example, it's just one example, and they don't necessarily use this as a complete alternative to a criminal path, but they've got a process that treats children who need protection effectively the same way as children who offend. They see all of those children as children in need, and there's a hearing system where people come together, different professionals who understand the child, social workers, etc., some volunteer community members, and they work out what is needed for that child, with the extra benefit of then being able to legally compel services to come to the party and provide that support. So I think it's worth looking at different options, but in terms of a basic need, really we just need to stop seeing this as a criminal justice issue. It's a wellbeing and support issue. Let's not pretend for a second that criminalising these kids works. Let's look at what kind of systems would actually provide the support and stop children offending, and ultimately not only do better by these kids, but do better by the community.
And thanks for that. And your view, Nerita, for Aboriginal kids and young people, what do you see as the solutions or alternatives to the criminal justice system?
Well, we certainly had one solution in place in terms of Balit Nalu, which wasn't just an Aboriginal Children's Legal Service, but was a service design directed by Aboriginal children who are in the system, who requested that not only have they have a lawyer to fight for their rights and their connection to culture and kin, but they also have a youth support worker who worked with them to develop their life plan. And you know, that life plan might have only been 12 months or 24 months, but it was a darn sight better than what they were getting anywhere else. And that focused on holistic healing. It focused on addressing their underlying issues. And as shown by the evaluation, it had fantastic results for those kids and kept them out of the system, and made sure that all of those trauma illnesses that they had, which most often for our kids is PTSD, as a result of the trauma that they've suffered, and also making sure that they were connected to their families and had positive role models in their life, so that they didn't see prison as the end game, but rather something that was not appropriate for them, and that their path might have been, you know, being a doctor, being a nurse, which we dearly need in these times, but, you know, being a teacher, all of those things were there. We also have pilots that just continually get year after year, just 1 year funding when they have fantastic outcomes. Our communities have had the answers for a long time, and yet they're not respected and they're not committed to, despite their great results. And we also just need to, and again, I know I'm harping on about this, but address the systemic racism within the system. We need to recognise the history of violence and dispossession and understand that's essential into understanding and addressing the shortcomings of our legal system, including the justice system, in which Aboriginal children continue to be disproportionately represented. You know, and those structures are laid down on the lives of generations of our people, and it is really hard to say that there will be fair outcomes without addressing those underlying acts of violence, in our opinion. And, you know, more broadly, there just needs to be a change in community attitude and redirecting funds. Stop investing in prisons, like I said, start investing in early prevention and diversion, dedicate more resources to the children most at risk, and make sure that it's always about, well, what works for that community and those children, because every community is different, every child is different, and we need to be flexible, and make sure that we are accounting for children's brain development. We are investing in restorative justice approaches and making sure that we intervene at the earliest possible stage and have wraparound support. That really is essential for changing the system and the outcomes for our kids.
Thanks for that. Anushka, I want to go to you. In fact, I want to go to all panel members just very briefly before we open up to a few questions that are coming through from the audience, and we do want to finish on time. But we have a large audience out there, Anushka. We had more than 500 people sign up to this webinar. What can members of the audience actually do to encourage reform? What can the wider community do if they believe that the age of criminal responsibility, being as low as it is, needs to change? You know, should they advocate their local MPs? What difference do public campaigns and advocacy make? You've been an advocate for a long period of time in relation to reform. What can members of our audience actually do? Over to you first, Anushka.
Thanks, Rob. I think they should do all of what you've just suggested. They should be speaking to their mates. They should be speaking to their mums and dads and families and colleagues and saying, can you believe that a kid who is 10 can be charged with a criminal offence, but they actually can't sign up to Facebook? That's what I think they should be telling people. And the other thing they should be saying is the sky's not going to fall in, because actually in 1992, the criminal age of responsibility was raised from 8 to 10 here in Victoria. And so we've got a precedent here. We can do it. And also, because of Dolly Incapacts, everybody agrees that kids under 14 shouldn't be held criminally responsible. So we've already got another precedent there in terms of everybody kind of agrees. We just need the system in place to be able to facilitate that. I echo Liana's comments in terms of, you know, there's been this discussion about what's the alternative, as if we need an alternative before we can contemplate raising the age. The key message is it's not an alternative. It's an engagement with the existing support system and structure that we have here in Victoria. We've already got the excellent groundwork. We've got a terrific education system, health system. Let's make it work even better. And imagine if we're not spending all this money on remanding kids, what we could do with that money. Mick Creedy, for example, from the Royal Children's Hospital said, imagine if you had a paediatrician in grade prep in public schools across the state. Why stop at even public schools? And then they're there saying, hey, and looking at what's wrong, you know, kind of what's going on with the kid, and then they're checking in with them. What grade prep, grade 3, grade 5, so that if there are signs that there's something going on, the kids are struggling at school, things are going home with the family, you can get in early rather than waiting for the youth justice system to kick in, because at the moment we rely on it too heavily and it's too late by that point.
Great, thanks for that. Narita, briefly, your view, what can the audience do? I mean, I know there's a raise the age petition that people can sign. You're probably going to mention that, but what do you reckon people can do from your perspective?
Well, I agree with what Anushka was saying in terms of people examining their attitudes towards crime and punishment, and then seeking to influence their families, extended families, friends, community. I don't care, your grocer, hairdresser, no limits. Just try and have that conversation so that we do change those community attitudes. And social media has a really incredible role to play in influencing people. And as part of the Raise the Age petition that you mentioned, Rob, part of that was posting photos of when you were 10, so that people could see the visual impact of what it would meant to have been in prison at that young age. And that approach is really important because it actually humanises children. Often in these debates, children are considered as abstract and other, and we don't consider the actual humanisation of them and their actual lives. And I think that's really important. So all the things everybody said, plus just utilising the tools that democracy gives you to raise your points.
And finally to you, Liana, anything further to add in relation to what people can do?
I think this builds on what's already been said. I think anything that lets the decision makers in government, the relevant ministers, people who hold the power to make these decisions, anything that lets them know that people have a view about this. Governments understandably know very well that there are a whole lot of community members who get worried about crime, who get worried about violence, who have views about young people who offend. Those people's concerns will be very clear in the minds of government. I think if people think it's not right that we criminalise young children, share those views, work out who the relevant ministers are in the state government, and share those views. Of course, I as Children's Commissioner will support raising the age. Of course, Anushka, Narita from different legal services are going to support raising the age. But if there are a whole raft of different people who work with children, doctors, teachers, the whole range of not the usual suspects who share their views in whatever way they see fit, I think that can really help.
Great, thanks for that advice from all of the panel. Now we'll just go to a few questions before we finish at 5, and there are lots of questions. We won't be able to get to them all right now, but there is a question to you, Narita. If we could keep our answers as brief as possible so we can get through a few questions. But the question is, particularly for Aboriginal kids held in custody, what are the impacts on them of being unable to practice culture whilst held in custody? And is this a right for children protected in international law that's not or should be implemented in domestic law?
Certainly it should be implemented in domestic law, and there are a number of things I wish Australia would implement in domestic law that they've signed up to via the UN instruments. In terms of being alienated from culture, it is isolating. It is detrimental. I think if you want to understand the long-term impacts of that isolation, then read stories and listen to voices of people who come from stolen generations, and you will understand just what it means for your life trajectory, and what it means not only for yours but the lives of your children and grandchildren, because that harm and that trauma that carries on. Just like our land doesn't forget trauma, neither does our bloodstream, and that's certainly very true for my people.
Thanks for that. Probably a question to you, Leanna. The questioner wants to know what sort of childhood activities are actually available in youth incarceration outside COVID-19. What can kids actually do whilst in detention?
So they have school, and school has been one of the better parts of youth justice in Victoria since Parkville College opened up. There's a pretty tailored approach to working out what children need and what will engage them depending on their age and depending on how much engagement they've already had with school, etc., etc. So that's part of it. Increasingly, youth justice is trying to improve the other kind of programs, activities, games, sports. That's been a slow process to my mind, and that's partly about the kind of staff shortages and other issues that have plagued the system for a long time. It's improving, but it needs to be much, much more. There's things like video games and those kind of things that I know for my 12 and almost 10-year-old, it's hard for me to get them off. But I mean, the point that you make, and I think you made another point later on in the questions, which is if we can't keep them out of custody, let's make sure that we're giving them the right kind of activities. I think probably I would say this across the board for children and young people, but particularly 10 to 13-year-olds, actually there's no way in which custody can be made child friendly and child focused and child appropriate. So I really do think I take your point, and there's a pragmatism. We've got to make sure it's as child friendly as possible now, but the real answer has to be keeping those younger kids absolutely and well and truly out of there in the first place.
Thanks for that. And a question, I guess, really to you, Anushka, and this might be the view of a lot of people in the community. Well, if offences are reported to police and the offender's between 10 and 14, what practices are proposed to ensure that young offender is held to account as opposed to it just being written off by the police as no offence? Surely, the questioner asks, without court orders, how can you get restorative justice practices enforced?
Thanks, Rob. actually think the questioner has actually provided the solution, or part of the solution in there, in terms of restorative justice. It's an excellent suggestion, and it's an excellent option. And to be clear, when we are talking about children under 14 who actually kind of commit offences, or even if we were to raise the age and they were engaging in antisocial conduct, there needs to be consequences. Harm has been caused, and so the question is, how do we actually address that harm? Restorative justice is a perfect way that we can do that, and so then there'd be a system. There are lots of examples of terrific restorative justice. I know the CIJ have been doing work in that space, the Jesuits. We've got the know-how and the expertise to actually introduce that system. Yeah.
Okay, well, look, can I, there are a number of other questions, but a lot of the answers have been addressed in the questions I've asked. Can I just thank you all as panellists for giving up your time on, the day before a long weekend. I really appreciate it. It is a very important issue. And I repeat what I said at the outset. Surely we can have a justice system that better deals with kids. And cast your mind back, everyone listening to this, cast your mind back to when you were 10, 11, 12, 13. Surely we have a justice system that can be a far more positive intervention, influence in people's lives than the one we have now, where there is still the ability to lock kids up as young as 10, 11, 12 and 13. The impact it's going to have on kids for the rest of their life is going to be an impact on all of us as a community. So we just have to think smarter. We have to continue the campaign to raise the age of criminal responsibility. You've given the audience some ideas as to how to do that. I would urge the audience, if you're fair income about this very important issue, that you take the advice of our panellists. This is really a call to arms, if you like, to put pressure on those who make the decisions to raise the age of criminal responsibility. I want to thank the audience for joining us and remind everybody that the recording of this webinar will be linked to all the socials, whatever that means, of the Centre for Innovative Justice. And I want to thank you, the audience, for being with us. I want to thank the panellists for being with us. And may we all have a great long weekend, particularly if Geelong win on Saturday night. Thanks very much.